cases, humanitarian law and human rights lead exactly to the same result. When it comes to torture, when it comes to rape, when it comes to deliberate killing of people in the power of the enemy, absolutely no difference. And simply one or the other branch provides more details on substance or provides additional implementation mechanisms. Now comes the question, what is a contradiction? And personally, I think that's an important issue. Is there only a contradiction if IHL prescribes something and human rights prohibits it? That was the approach in the Al-Jeddah case, where they said there is no contradiction because IHL allows internment and human rights prohibits internment in this context. If this was true, I know only one single contradiction between IHL and human rights law, but perhaps you have some other ideas. There's only one example. The law of occupation prescribes military courts in occupied territories, and human rights law, at least as interpreted in Europe and the Americas is only south of the Rio Grande because Canada and the US are not a party to the American Convention. It is prohibited to bring civilians before a military court. But that's the only example I know. But if we are realistic, we have to admit that even if IHL permits something and human rights law prohibits this, there is a contradiction. I mean, under IHL it is lawful to kill enemy combatants. Under human rights law, you would have to try first to arrest them. And there, I think, we have to solve the tension. All this is also related to an important issue whether IHL authorizes at all anything, and this is the Lotus debate we are between international lawyers, so I don't give more details, which in my view remains a very theoretical debate until we have human rights law, because human rights law requires a legal basis for detaining people, for killing people, and here a lot of people and states try to argue that my legal basis for killing this person or for detaining this person is IHL. And then there can be a contradiction. Lex specialis. Well, the problem is, I think the term, is because he doesn't like and I like it, but for the rest, we mostly agree. So it's a pure terminological thing. And why doesn't he like it? Because it's often abused of and misunderstood. And I say self-defense is also abused of, and a lot of rules of international law are abused of, but it's not a reason to abandon them. But okay. So some people say lex specialis means only IHL applies in armed conflicts. And this is wrong. I think it's also wrong to say whenever IHL has a rule, it's the rule of IHL which applies. And therefore I understand those who don't like lex specialis, because it looks as if human rights don't apply wherever there is a problem covered by both, because I mean freedom of press is not covered by IHL, and therefore most people would agree that it nevertheless applies even in armed conflict. I think the issue is not either which is the more protective rule. This is the rule in human rights law. If you have two rules, you choose the more protective one, but between IHL and human rights law, it would be meaningless, because in 98% it's the human rights. I hope in the ICRC will not fall down when I say human rights law is more protective than humanitarian law, but humanitarian law is more realistic in armed conflict than human rights law. So it is indeed, according to me, the more detailed rule, as you say, the rule which provides in respect of certain facts, because I would say it's not even a relation between two rules. It's a relation between two rules in respect of two facts, one or the other, has a greater common, that's one of my students who created this term, a greater common surface, contact surface area between the facts and the rule. And therefore, and there most people disagree with me, in my view, sometimes it's IHL, which is the lex specialis, and sometimes it's human rights law, the lex specialis, but there is, again, it's mainly a terminological issue, because those people would simply call it the lex generalis, which prevails sometimes. I would say the two can constitute, in a certain situation, the lex specialis. The alternative, and you mentioned the Vienna Convention, and at least one of my students is a total fan of that. The solution is the Vienna Convention, which, by the way, doesn't mention lex specialis. So the idea of systemic integration to interpret one, taking the other into account, often leads, in my view, to the same results. It also raises the question, what is interpretation? And here we will discuss about a case where the European Court on Human Rights simply changes a rule of human rights law in saying, I interpret this rule in light of IHL, and I think this is slightly abusive. Another question is, lex specialis is a relationship between two treaty rules, while often, especially in non-international armed conflict, we have customary law, and at least under traditional customary law, you don't determine lex specialis between two customary rules. You just try to determine which is the customary rule applicable to my problem, out of state practice and opinio juris applicable to that problem. And then comes lex specialis by analogy, because you know most of the problems are in non-international armed conflict, and we don't have rules on many issues in the treaties on non-international armed conflict, but states try to apply by analogy the rules of international armed conflict, and this goes for me a little too far to claim the lex specialis is something against hard human rights law, which we draw by analogy from another situation, which is international armed conflict, but this is very controversial. And finally, just 2 points, lex specialis through jurisprudence, because often we say human rights law is much more detailed on many issues. But it's not true if you look at the treaties. It is only because there is much more jurisprudence of human rights bodies, but this does mean that the lex specialis shifts, and in my view this is not possible, all the time between every time a human rights court takes a decision, the lex specialis moves, and then comes the International Criminal Tribunal for the former Yugoslavia, which gives a more detailed interpretation of a rule of IHL, and then the lex specialis moves again. I'm skeptical about that. And some of you mentioned it. I think it's also a question of the enforcement mechanism. Perhaps it also depends very much which mechanisms uses it. But obviously, if I'm a state, if I'm a human rights court, theoretically, I don't favor that. They could simply apply human rights and say, we don't care about IHL. But if I'm a state, I'm bound by both. So I have somehow to integrate the two. The suggestion that jus cogens erga omnes and so on is helpful, is certainly with other rules of international law. But you know, in human rights and humanitarian law, where it comes hard to hard, probably both would claim they are erga omnes and to jus cogens, and therefore it's not very useful. And on the derogation issue, the problem is simply practical. In my view, in the ICRC I can say that in a human rights body I would be expelled. States should more often derogate. But the problem is most of the time they don't derogate. And this creates the problem. Because if they derogate, it's exactly what you explained. But most of the time, most of the states concerned by armed conflicts do not derogate. And therefore, we cannot say, now derogations have to take into account other international obligations, because they didn't derogate. And the European Court on Human Rights in the Afghan case found a very strange and dangerous idea to say subsequent practice shows that you don't have to derogate. And I must say, this is very dangerous, because subsequent practice shows a lot of things which could be a violation of the European Convention. Thank you.
Thanks, Marco. I feel compelled, though, quickly to say something about
Yes.
lex specialis.
Yes.
Here is simply, my problem is this. First of all, this issue of it meaning all things to all people. I recall sitting at an expert meeting maybe 7 years ago or something, and we were discussing this precise issue, and there were 20 people around the table, and the question was asked, what's the solution to the interplay? And you go around the table, and everyone said lex specialis, and then someone wanted to move on. That's fine, we're okay. And then I said, hold on. And I just asked, just a few people, what do you mean, lex specialis? And every single one of the people that said lex specialis meant something completely different, but completely different. One was going to completely displace human rights law, the other meant that lex specialis is human rights law, and and on and on and on. And to me, when something means all things to all people, it's not a helpful concept. And yes, there are lots of areas and principles where we have debate, but I think it's served to obfuscate the debate here. It's too easily, it's the abracadabra. We say it's Latin, it sounds smart, and then we think we've got the answer, and we don't try and deal with it. And so my concern is that. The other concern is that, and actually I think in many ways we agree on this, and some of the comments that were made, is that it gives us the impression that the answer is a top-down principle, that you have one sort of legal theory answer to all of the problems that can arise between human rights and IHL, and you just you apply this principle from the top, and that's fine. And I think the answer is bottom up. It's case by case, and context by context, and the interplay between human rights and IHL will operate differently in every different scenario. And for that, I would just say watch this space, because within a year we're going to be publishing a project that I'm involved in Chatham House in England. We're putting together a human rights manual for the military. Now it's it's meant mainly for the UK military in the context of ICRC, but obviously it'll be wider than that, and it's and it goes chapter by chapter. It says, in detention, this is how human rights and IHL operate together. When you're manning a checkpoint, this is how human rights and IHL operate together. In use of force, this is how, and I think that's the only way we're ever going to be able to solve this, is if we stop trying to think that there are legal answers, but we just say, in this context, that's what you do. In this context, that's what you do, and we just come up with that. But again, I don't think we're actually that far from each other in terms of how we solve it.
For you, regarding the issue of the competence of the military court, what might be your answer?
And I agree. This is probably, and I agree with Marco. I've said this as well. This is the one where we have a clear contradiction. I think some of that will end up being solved possibly in two ways. Either state practice over time will coalesce around one of these rules, and it may well be human rights law. With time will prevail. We'll just see that more and more states are accepting that you don't bring civilians before military courts, even if the Fourth Geneva Convention allows it, and that might simply be
Describes it.
Yeah, and that might simply be that we just see practice changing, and that becomes and I think that's probably the likely way out of this. But
I would disagree, because the problem is the overall systemic purposes of international law have to be taken into account, and an occupying power may only have a military presence and may not constitute civilian courts. Otherwise, it would be an annexation, and therefore I think. Here the IHL rule prevails because it represents an overall purpose, while an occupying power bringing people from the occupied territory before its civilian courts would either deport them, which is prohibited, or annex the occupied territory. So as soon as occupation no longer exists, I agree with you. But as long as this old-fashioned phenomenon exists, we have to deal with this specific.
Yeah. Well, the remainder of what I was going to say was that I think we may also see within practice very limited exceptions being formulated in practice, exceptions to human rights law, and that human rights bodies may accept that there will be very limited situations in which you do, and then the focus will be on the independence and are these courts within a certain chain of command and so on. So I think it'll be solved through state practice, which will, I think, generally fall towards human rights law with very limited exceptions in very specific contexts. But we don't know. Yeah, we can wait and see. It's not. All we're doing here is we're guessing how is this going to be solved in the future. So, I mean, I'm not right. Marco's not right. You're not right. Nobody's right because we're predicting the future.